Have you received a legal bill and thought, this is too high, and I didn't agree to this much work? In Australia, you do have rights to challenge your bills. You don't have to pay it quietly. Today, we will walk you step by step through what you can do if you are unhappy with your lawyer's costs, how to negotiate, how to object, and how to seek a cost assessment. Let's get started. What legal rules apply to lawyer costs in Australia? If you are in New South Wales or Victoria and in other jurisdictions adopting the model law, the relevant regime is the Legal Profession Uniform Law and associated regulations and rules. Under the Uniform Law, the lawyer must provide cost disclosure when instructions are taken, including how their costs will be calculated and an estimate of total costs. A costs agreement must be entered into before work starts or as soon as practicable. Without valid disclosure, the agreement may be void. However, there is some exceptions. For example, a cost agreement is not required if the total legal costs are unlikely to exceed $750 excluding GST and disbursements. Legal costs must be fair and reasonable. The key takeaway point is that your lawyer cannot charge whatever they like. They must comply with disclosure, cost agreement, and reasonable cost standards. Now you understand the rules. How can you challenge a bill you believe is unfair? Let's go through your options. Let's start with some tips and general principles. If your lawyer charges you for these items, you may raise objections. Number 1. Lawyer cannot charge any time for general legal research. Why? Because they are supposed to know the law. So if any work regarding legal research, such as reviewing case law, searching applicable provisions or statutes, are recorded in the bill for drafting a letter of demand and some contracts, you may raise objection. But there are exceptions. For example, research time before the trial may be billable, but only to the extent that such work is reasonable for prudent preparation of the submissions before the hearing. Number 2. Lawyer cannot charge you for sending you an invoice and responding questions regarding your costs. It will be unfair if clients get charged if they only ask questions about some items recorded in the bills, which they are entitled to know anyway. Number 3. Internal conferences between the lawyers themselves are normally not chargeable unless the lawyers can show that they are necessary to conduct the case efficiently. That makes sense because you cannot charge 3 times if 3 lawyers in that office chat about your case between each other. That's counterproductive. But if a junior, after working a few hours, is to report to a senior as to what has been done, then that's considered as efficient. Number 4. If lawyers charge you for the time of traveling to and from court or conference, you have a good chance to negotiate with them and have those cut to 1/2 of the rates. However, out-of-pocket expenses such as taxi, flights, or accommodation should be allowed as disbursements. Number 5. Lawyers cannot charge duplicated work. It is not reasonable to have 6 lawyers attending a same meeting and charge you 6 persons' time spent during that meeting. It's common that for relatively complicated cases, there are a senior and a junior involved, so that senior is responsible for reviewing and such mechanism will be more efficient. But be careful when too many people are involved when it becomes unnecessary, resulting in duplicated work or cost over-reporting. If you are unhappy with your bill, start proactively. You don't need to go straight to formal assessment. You can first raise a concern with your legal practice. These are the things that you can do if you want to challenge a bill. Number 1. Ask for a detailed bill or itemized invoice. Your lawyer should provide one upon request. This is under Section 187 of the Uniform Law. Number 2. Ask how the fees were calculated, the hourly rates, who worked on your file, is a senior partner or junior associate, what tasks were done. Number 3. Ask whether you were properly informed of scope changes, extra work, or disbursements. The Uniform Law requires that if costs will exceed the estimate, further disclosure is required. If your lawyer cannot justify the fees, or you suspect the work was unnecessary or duplicated, you can raise a formal objection. This might involve writing a letter to the law practice outlining why you consider the bill unreasonable. For example, I believe the number of hours is excessive. I didn't receive prior warning that the cost was going to exceed the estimate. I was not informed of key tasks that generated legal fees. Keep records of all communications. Many cost assessment decisions look at whether the client was informed and whether the lawyer acted reasonably. It's important to note that raising the objection early is crucial. Deadlines apply for formal assessment, which we will cover shortly. If informal objection doesn't work, your next option is go to a formal cost assessment. Here's how it works. A cost assessment is a process where an independent assessor or court reviews whether your lawyer's costs are fair and reasonable and determine whether it should be payable. Under the Uniform Law, this is set out in Part 4.3. For example, under Section 199 of the Uniform Law, it says, on a cost assessment, the cost assessor must determine whether or not a valid cost agreement exists and determine whether legal costs are fair and reasonable. And to the extent they are not fair and reasonable, determine the amount of legal costs that are to be payable. So who can apply for cost assessment? A client may apply for assessment of costs charged by their legal practice. Sometimes third-party payers or legal practices themselves may apply, but certain commercial clients or government authorities may be excluded in some jurisdictions. You usually must apply within 12 months of the bill being given or of payment being requested in the Uniform Law regime. So what are the steps in process? Firstly, you need to submit the application with the required forms, including copy of invoices and cost agreement to the manager, cost assessment, or registry. Number 2, the respondent, being your lawyer, gets 21 days to submit objections or reply. Number 3, costs assessor will then be assigned to review material. They may request further documents, then issue a certificate of determination. And that certificate sets out what costs are payable. Number 4, the certificate of determination can be enforced as a judgment in court. What are the assessor considers in cost assessment? Firstly, they will consider the validity of the cost agreement and what is the scope of legal work concerned. Secondly, they will consider whether costs are fair and reasonable, factors including complexity, urgency, skill, time spent, rates, outcome achieved, and whether work was inefficient. Next, for matters under Uniform Law, the test includes whether costs are proportionately and reasonably incurred, and what is proportionate and reasonable in amount. What happens next? Well, if the bill is reduced by assessment, you only need to pay the less amount. If you already paid, you may have refund rights. If you disagree with the determination, there may be an appeal or review process, which may vary by jurisdiction. The average recovery for solicitor client costs by cost assessment is about 85%. The rate is 60 to 75% for party costs, which you don't need to know for the purpose of this video. The takeaway point is that if reviewed by a cost assessor, the chance is that your bill may be reduced by 15% at average. There is another tip. Cost assessment can be complex and sometimes expensive. Many clients engage cost lawyer to advise. But as a client, you don't need to accept the original bill if you believe it's unfair. But cost disputes don't always mean an assessment is needed. What else can you do? Let's explore other remedies and practical steps. Besides a formal cost assessment, you have other options. Firstly, you can make a complaint. If your lawyer failed to give proper disclosure or charged significantly unfair costs, you may complain to the relevant legal services commissioner or regulatory. Failure to comply by your lawyer may amount to unsatisfactory professional conduct or professional misconduct. Second, check if the cost agreement is valid. If the required cost disclosure was not given, the agreement may be void, and you may be able to refuse to pay until assessment. For example, a lack of estimate or basis for costs can affect validity. Number 3, use court or tribunal orders if applicable. If you are in a litigation and a court-made costs order, you may have a party costs assessment process as well, depending on jurisdiction. So you may recover the costs against the other party. Here are the practical tips. Keep all the bills, costs agreements, disclosure documents, and emails discussing fees. If you think a bill is unreasonable, act promptly within the applicable time limit. Delay may limit your rights. Ask for a detailed breakdown of the work done, the time incurred, and disbursements. Lastly, ask about the likely outcome of the cost assessment. Sometimes a lawyer's costs get reduced by 10 to 30% or more if deemed excessive. To wrap up, here are the 5 things that you must remember. Firstly, cost disclosure matters. Your lawyer must provide written disclosure early, and you should receive a cost agreement or at least disclosures under the Uniform Law. Number 2, ask questions and keep control. Don't assume the bill is fine. Ask for breakdowns, challenge unclear costs. Number 3, you can apply for a cost assessment within time, often 12 months, and with the right documents. The cost assessor can reduce the bill if it's unfair. Number 4, other remedies exist, including negotiation, complaint to the regulatory body, or relying on court or tribunal cost orders. Sometimes a simple negotiation or mediation works. Lawyers are keen to avoid formal disputes with their clients and preserve their reputation. This video is not to encourage you to dispute every bill received from your lawyer. That will burn the bridge very quickly. The purpose is to educate yourself about your rights. If you are ever unhappy with what your lawyer is charging, you now know what can be said and done. Thanks for watching. If you find this helpful, please hit subscribe, like, and feel free to share your experience in the comments. Have you ever charged with a legal bill that is so unreasonable? What happened? We'd love to hear from you. See you next time.